A very warm welcome to our viewers today watching this program. Today our program is a discussion on the amendment of and also introduction of new criminal laws which are taking into force from 1st July 2024. Today, as we are discussing the amendment and introduction of new laws, we are highly appreciative of Deputy Inspector General Sir Marak to join our panel. A very warm welcome, sir.
Thank you.
Today for our viewers, sir, they have all heard about this new introduction of laws, and there has been renaming of laws of our archaic colonial laws. So it would be really insightful for our viewers today who are watching this program, sir, if you could just give a brief overview about what these laws are and why this change.
Yes. As you rightly pointed out, these laws are archaic in nature. In fact, if we trace the historical background of these laws, there was an attempt by the colonial rulers, that is the British, to have a criminal justice system which was uniform throughout the country. And it started with the Indian Law Commission, headed by Lord Macaulay in the year 1834. And which gave some certain recommendations for a uniform codified law which will be applicable throughout the country. So in response to that, in 1860, the Indian Penal Code, or the IPC, was enacted. Later in the year 1872, the Indian Evidence Act was enacted. And later in 1898, the Criminal Procedure Code was enacted, which was later amended in the year 1973. Now, to give a brief background, the reason why these new criminal laws have been enacted, or rather why the change in the nomenclature of these laws, we have to understand that in 1860s, when the laws were being enacted, yes, it was made with the intention of having a uniform laws throughout the country. However, the background was that India was a colony of the British, and the British had enacted these laws to colonize the people of India. Not only that, the ethos, the society at that point of time, the mindset of that period of time was reflected in the laws of that period. And in the last 160 years, a lot of changes have happened in our society, and the views and the philosophies which were relevant maybe 160 years back are not relevant in our present times. Having said that, the focus of IPC specifically, or the Indian Penal Code as the name suggests, was a penal code, or was a code to punish criminals. Now, if we see the corresponding amendment, that the Bharatiya Nyaya Sanhita. So the word Nyaya itself means justice. So there is a shift from punishment to justice.
Right.
So that is the reason why this nomenclature from the Indian Penal Code has now transformed into the Bharatiya Nyaya Sanhita. Secondly, thirdly, I would also like to point out that there were many archaic sections of law. For instance, one law which was applicable at that point of time, or which rather the colonial powers wanted in the laws or in the IPC, was the law of sedition, where anyone who said anything against the British were booked under this section.
Right.
So this present amendment in the new criminal law, in the BNS, sedition has been done away with. There are certain sections of law in the old IPC, for example, section 377, or unnatural sex and all that. So that has been done away with. So many such sections which were not relevant in this present times have been deleted from the IPC. Secondly, with the changing times, there is a need to incorporate new types of crimes which have come about. And in the IPC, one of the major changes that in the IPC, we didn't have any law on like mob lynching, on organized crimes, etc. So these kind of laws have been incorporated in the new amendment. Further, in the new criminal laws, there is a big thrust on the use of technology. For instance, now in the BNSS, which is the corresponding law to CRPC, now it is mandatory to use video recordings, audio-video recordings during search and seizures. Earlier, that was not required.
Right.
Further, the use of judicial evidence has now, in the Evidence Act or in the earlier Evidence Act, there was no provision of using digital evidence. Now, in the new Bharatiya Sakshya Adhiniyam, there is now a provision wherein even digital evidence has been given the same importance like other sources of evidence, which like the primary evidence or the secondary evidence in the old Indian Evidence Act. So, and finally, the objective of this new criminal amendments is basically to give justice to the people, to make justice more accessible to the people. Like for instance, now in the new amendment in the BNS, specifically section 173 of BNS, there's now a provision of filing zero FIRs and EFIRs. So what it means is that people can now go to the nearest police station and file a zero FIR, not necessarily go to the police station which has the jurisdiction where the crime has occurred. And further, they have now the opportunity to go and file FIRs, EFIRs from anywhere in the country. So these kind of provisions, which are the need of the hour in these modern times, have been incorporated in these new criminal laws.
I think you very briefly actually said the entirety of it, that what the provisions actually provide, and the dynamic paradigm shift in the thought process also of addressing the issues and the crimes which are taking place. Because as you have rightly said, with the new amendment of laws, we are seeing, before that actually, we have seen again, pre-COVID, during COVID, post, of course, the entire work process has also become, at least if not entirely in digital, which was during, it is following a hybrid, a hybrid system. So also we, as there are a lot of laws which are again, formulated, but it also had to undergo, like you said, because of change of crimes. And now what would used to be the crimes which were just at a physical level, even digital, you just spoke about digital evidence, and I think this is one actually becomes one of the most soft targeted and easily targeted for even in our own state. And everywhere that digital attacks happen, crimes are happening digitally at a vaster place. What we used to talk about sexual harassment is taking at a much more major, at a major, I would say, more, regular and easily targeted women or men because of digital platforms, accessibility, how the crimes. So you have very, very rightly pointed that with change of time, the change of crimes are happening, and this especially when we talk with regards to BNS, the penal law, which has been renamed and changed, and rightly so you have said that before it was just for punishment, and now it is being as nyay, that means justice. So I hope our viewers will be at least encouraged to feel that yes, what was previously called as just for penal, that is for punishments and identifying the crimes, but now it is looking at a broader spectrum of actually identifying crimes for furtherment of and more easy, accessibility to justice. One of the other things, sir, you've said that zero and EFIR. So could you just for our viewers, so that they know, I think it is very, very important when we are doing this, a discussion, our viewers who are watching today are more aware, because until we talk about it, our viewers or even people in general will not actually understand what it is about. So it would be very helpful, sir, if you could kindly just, elaborate a little bit about EFIR or what you said, a zero FIR. So our viewers today who are watching will be more aware, and they'll be more, aware of their rights, and will know if, God forbid, anything happens, how to go about it. So that will be very helpful, sir.
Okay. Well, actually, the concept of zero FIR is not something which is new. In fact, it has been in place for some time. However, the applicability of zero FIRs as far throughout the country was not uniform. So I believe that the BNSS has tried to remedy this and has brought about a change wherein they have specifically mentioned zero FIRs under section 173 of the BNSS. Now, what a zero FIR actually means is that, say, supposing a crime has been committed and a person may actually, in a traditional sense, if a crime has been committed in a certain police station jurisdiction, the victim is expected to go to that police station and file an FIR in that particular police station. However, the zero FIR now is a concept wherein the FIR need not be filed in the jurisdiction of the police station where the crime has occurred. It can be filed anywhere in the country.
Okay.
So, what that and now by law, the police stations are mandated to accept those FIRs also if it is filed even in any other police station, not necessarily in the
same jurisdiction.
Same jurisdiction. They are mandated to accept it and forward it to the concerned police station. So that is the concept of zero FIR. Now it's called the zero FIR because usually when an FIR is filed, we give an FIR number, like it's a case number basically, and it goes serially. So since that zero FIR will be filed in some other police station which does not have the jurisdiction to investigate that case, so they will not be giving any serial number to that. That's why it's given as serial number 0.
Okay.
And it is forwarded to the police station which has jurisdiction, which will then register this zero FIR as a regular FIR. It will be given a proper case number and it will be investigated into. So that is the concept of zero FIR.
Right.
Now, the BNSS has made this a part of law. Earlier, there was no such express provisions in law for registering a zero FIR. Now, another new concept which has been introduced in the BNSS is the filing of e-FIRs. Now, earlier the problem, many citizens, they feel scared of going to the police stations for several reasons.
Very true.
So many a times crimes get unreported.
Right.
So now, and even there are also reports that probably even when a crime has been reported, sometimes such cases or FIRs are not registered in the police station. Now, to remedy that, I believe the BNSS has introduced a concept of e-FIR, wherein a person can file a complaint or an FIR through email to the concerned police station, and the police station will be mandated to register that e-FIR within 3 days of receipt of that e-FIR. So, which will be again treated like a regular FIR after it is received. So, these are, I would say, momentous changes as far as the police is concerned and investigation of cases are concerned.
I think that's a very, very important part of what BNS and BNS have made and these changes. And so you've rightly pointed, and I'm sure our viewers who are listening today and viewing our program today will take that as, you know, something which is also very public friendly. What we look into, how we have said that a zero FIR can be filed from any place, anywhere in country. So that makes it very, very public friendly first. And also when you talk about how you have highlighted that FIRs, yes, the one thing is that as public, and I'm sure our viewers can relate to, or perhaps might be having in question in mind that, yes, okay, fine, that how you have rightly pointed out that people are scared. The very concept of going to a police station intimidates them. And I think these, very, very major changes, momentous changes, as you have quoted, is very true. And it is also seen through the, what you said first, coming back to your first statement, you said to give justice. So making justice accessible, like while filing the entire procedure of it, and of course from the police, the penal laws coming into. I think it is a very, very effective system, at least when you look in through the lens of more of public related goals, or giving more access that people can actually file complaints. You've said that yes, most of the time the cases are not filed because they are too scared, or they don't know how to go about it. So I hope, our viewers having questions in mind, sir has rightly addressed them, hopefully, and now you know that from wherever you are, and if you're facing any kind of issues, any a crime has been committed, or you want to report for that matter, you know that you can do through even e-filing to that particular jurisdiction, and how sir has said that it has to be registered within 3 days. Jurisdictions have been mandated, the police stations have been mandated to register it within a time span of 3 days. So I think that is very, very helpful for our viewers today. Coming back to sir, as a police personnel, because there's a police first point of contact of any crime, and actually plays one of the very, very, I would say, the crux of any investigation or any when a crime is committed. The first ones of point of contact, and the first step of actually a step towards at least applying for justice. So coming back to that, sir, how do you think you have already highlighted there are so many plus points. You've said in your first thing that so many laws or so many archaic laws have been done away with, because in today's relevant time it is no longer applicable. One, of course, it comes through the judgments, even Supreme Court precedent judgments, landmark judgments have been taken into consideration while again revamping these laws. So that again 377 comes in from a landmark judgment which had happened. Coming back to the changes of sections and the importance of newly added sections or newly change of crimes being identified, how would you say, sir, as an investigating officer yourself, the challenges are still, if so, and especially when you relate to our state? Because of course, again, when you talk about crimes and different kinds of crimes, even demography wise also matters a lot. You could see some in places where there are a lot of trafficking happening. In certain places there are a lot of say digital crimes more on occurrence. So if you could highlight, so that even our viewers would know that okay, these are the challenges we can unfortunately face, or we are perhaps facing, we don't know how to go about it, or how we, at least now we know that okay, these are the things that have been taken care of in our state specifically, sir.
Well, I'll answer your question in two parts.
Right.
When we talk about challenges faced by the police, yes, there will be a lot of challenges faced by the police because these are new laws, right, and it will be implemented from the 1st of July. And only when we start implementing these laws, we will be actually facing a lot of roadblocks as far as procedures are concerned, because there are no precedents set. So we have to, of course, in some cases, certain procedures have been prescribed. However, actual implementation in the field will be a challenge.
Right.
Now, for instance, I just want to give one example here. Now, in these new laws, during the search and seizures, it has now been made mandatory to record the entire search and seizure process through videography.
Right.
Now, however, and it further says that these evidence, the search and seizure process, needs to be transmitted to the nearest magistrate within 48 hours. The challenge that we foresee, as far as the police department is concerned,
right,
is yes, now supposing in a very remote location in Meghalaya, which does not even have access to, let's say, internet or electricity, and where there are no networks, and we have to seize some contraband. That procedure itself will be recorded through videography or mobile phones or whatever. The problem of transmitting it to the nearest magistrate within 48 hours is going to be a challenge.
Right.
The manner of how it is to be transmitted again is going to be a challenge, because that has not been specified.
Right.
Like, how is it? Is it going to be in the form of memory cards? Is it going to be in the form of pen drives? Is it going to be in the form of CDs?
Right.
That has not been specified. So when we actually implement these laws, then we will actually find these kind of problems, and then that is going to be a challenge on implementing these laws. Now, coming to the second part of your question, when you talk about certain laws which would affect our state. I feel there are many provisions in law which may directly impact our state. Like for instance, in Meghalaya, especially in the Eastern Range, where Eastern Range basically is the whole of Khasi Hills and the Jaintia Hills, we have a lot of cases or several cases of mob lynching. Earlier there was no specific crime of mob lynching.
Right.
Now this has been introduced in this amendment, wherein it says that if 5 or more persons commit a crime of either killing a person or maybe seriously injuring a person, that will be treated now as a mob lynching case. And the punishment prescribed for such a crime is very, very severe. If the person dies, then the punishment may extend to death sentence also. So this is one thing, because what happens here is due to several factors, be it culture, be it religion, be it some other social economic factors. So there are times when we had cases here when a huge crowd had gathered and maybe taken action against certain criminals, or rather they have taken law into their own hands. So right. These kind of cases now will be treated as a mob lynching case. So this is going to be a challenge for the state as well, and as well as for the police. The second aspect I feel which is going to impact our state in a significant manner is the concept of organized crimes, which has been introduced with the new amendment. Now, in the organized crime, there are many crimes which are committed in an organized manner. It could be organized terrorist, gangs,
or an entity,
foreign entity. It could be money laundering. It could be maybe smuggling activities. Like we have cases of, for instance, we have cases of cattle smuggling, betel nut smuggling, and so on and so forth.
Yes.
Legally, the police will always have a problem in tackling this kind of these problems, because there were no express provisions earlier. Earlier, the word smuggling itself was defined only in the Customs Act, for which police had no jurisdiction to act on.
Right.
Now, however, with the context, with the new amendment here, these will come under the provisions of organized crime, and therein we will be able to take action against such kind of crimes also.
True.
So I feel these kind of crimes are relevant to our state, and perhaps now the police will be able to tackle them more effectively.
And I think what you rightly said, sir, and I'm sure our viewers also, viewing this program would take back, is that a very, very important point you've highlighted, both as a challenge but also as a helping hand. One, it gives you that, okay, previously it was very difficult for police to categorize, or in a situation like this, or say even what you've referred to as a mob lynching. Unfortunately, yes, specific to our region, sometimes without understanding the impact, or perhaps for the judiciary or for the police especially, becomes a challenge. How do we club so many members into one, and how do we identify? But now with this strict, of course, the challenges, like you said, is going to be momentous, and then only you can realize perhaps what further probably, amendments are required, of, I'm sure of it, because what is written and when implemented at a practical field are a lot of challenges. And one such challenge which you have very, very profoundly reflected, especially in our place where network connectivity is still an issue. So because of that, immediately providing a video, you can record it, of course, but how do you put it within that time frame? And the other challenge, again, how you have specified, is that they have not specifically, they have said, okay, videography and digital evidence is fine, but in what format to be presented before the court, or how do we proceed if the defense challenges it? That it seems like a big loophole. Of course, I know. Well, law is how you interpret it, and it's a challenge for both the practicing lawyers, judiciary, and police. But it seems like having a big loophole, which can be, in a way, interpreted or perhaps given an ammunition to the defense as to in which way did you collect the evidence, and if it was it, how do you verify, in the sense of what format? I think this is the biggest challenge as investigating officials will face, especially while presenting it in the court. Giving an ammunition to the, unfortunately to the defense, of course, that yes, it's a big loophole. And how you rightly said that while the laws in paper sounds absolutely wonderful, and they have actually identified the certain crimes which you have said time and again, and they have done away with certain crimes which are no longer relevant, but while implementing in a practical level, especially demography-wise challenge. Again, some places they might not be magistrate available within a thing. So that these becomes again a practical challenges coming to that. The other thing I would like to, I would like our viewers to have a better understanding of when you say of Bharatiya, specific to Bharatiya Nyaya Sanhita, you've already highlighted the sections, in the beginning itself, that these are the certain sections which play a very important role in at least addressing our future problems. The other challenge is how do we they have made it, they've identified, they haven't, but when it comes to the other part of the law of evidence collection and actually how to present it, that becomes our biggest challenge. So if are we to say that for a viewer, for a viewer listening, or for a lay person, one, you have already said about the zero FIR and all, but when it comes to say a little bit, I would want to, for our viewers, since we are talking about the BNS, a little bit on the evidence part, like so that as viewers, if nothing else, we know what to keep. Because since, everything is connected, when we talk about penal laws or when we talk about, say, evidence, which is known as now Bharatiya Sakshi Adhyan, that is also some way indirectly plays a role, at least when it comes for a person to complain, a complainant. So if you could just put out certain, just a little bit of idea, so that we know, which will be relevant in context to the changes, of course. So as viewers or as lay persons watching our program today, we know, okay, like sometimes a conversation we don't think it's relevant, or sometimes we don't think that, okay, this is something we can, keep as an evidence. Perhaps they will do their own investigation. So as viewers or as complainants, what can we do in relevant to, like, at least keep in mind, if God forbid something happens like this, to, at least help in aiding for the investigation, make it easier for the police investigating agency too?
Yes, it's a very relevant question. And I think one very important provision has been put in the new amendment. For instance, now, as far as the victims are concerned, and as far as the complainant is concerned, it is now mandatory, as by law, to keep the complainant and the victim informed of the progress of investigation within 90 days of filing of complaint. And from time to time, the victim and the complainant will be briefed of the progress of investigation. So I think this is a very positive step, in a sense that the victim and the complainant also knows what is going on in the investigation, like you pointed out, what kind of evidence needs to be preserved and kept.
Yes.
And he or she will be able to track the progress of investigation. Earlier it was not done so, but now with this law, it has now become mandatory to inform the complainant and the victim as well about the progress of investigation.
I think that's a very, very important take for our viewers, that first we keep abreast of what we are doing. We can continue to talk on so much more for our viewers, and it is such an interesting topic to have a better understanding. Like you said, as lay people also, we need to know, if not the entire procedure of it, but at least the basic, which you have so poignantly pointed out, sir. And unfortunately, we are running out of time. We could continue for a long, but just your parting shot to our viewers and everyone who's watching the program today. What would be your parting shot before we close up?
My parting comment would be that this new amendments are a welcome amendment. It is futuristic. It is in tune with the times. Yes, we will face challenges, but I'm sure with the cooperation of all the stakeholders, we will achieve what this law has set out, want us to achieve. And with that, I have full faith that the objectives why these laws were amended will be fully met.
Thank you so much, Bamarak, for being a part of this discussion. And you have given us so much of information. We could always look for more again. Thank you once again for being a part and enlightening me and our viewers today who are watching. Thank you once again for being a part. And our viewers, I hope you have been enlightened as I have been with such wonderful information from our sir here. And I hope you take back and understand how sir has highlighted that anywhere you can file an FIR, which is a zero FIR. And the other important thing, one of the important thing for us as lay people to understand is that we can file a complaint through email. Thank you once again, our viewers, for being a part of this, and till next time.